This symposium represents a special melding of the justice system improvement efforts and legal advocacy initiatives our respective organizations have been promoting for many years. In planning this symposium, we continually grappled with the question, what do we mean by public policy in this context?
This symposium about the Gideon ruling and how to implement the right to counsel for indigent defendants is right in the wheelhouse for the School of Public Affairs. In that, we try to sort through how the politics and the policy can make meaningful implementation and the challenges that we face when we try to do that. Now, everyone in this room has experience with the challenges of the implementing the right to counsel. This is something that universities are particularly good at, convening a group of smart individuals to come together to sort through the issues and develop ideas that we can move forward in making the policy better, in making the implementation of the policy better.
Now I have to mention that at the Washington College of Law we have numerous publications and programs that consider Gideon's implications in different ways, and I'll just mention a few. The Criminal Law Brief was launched in 2005 to analyze the complex and constantly evolving criminal justice system, including issues relating to the right to counsel. Close to my heart, the Criminal Justice Clinic, which I co-direct, teaches student attorneys about the theory and practice of advocacy in our criminal and juvenile court systems. The students work in teams mostly in Montgomery County, Maryland, representing indigent clients charged in those systems, and they're responsible for all aspects of the client's case. The law schools also just formed the Criminal Justice Practice and Policy Institute, and one of our goals I wanted to read is encouraging effective voice by everyone with a stake in the system. And this event certainly brings together many different people with a stake in the system in what we fully expect will be an important collaborative discussion.
Not just in isolated places, but across the country, every single day. Why are we standing here today, 50 years later, having this conversation when we have this, I think one of the greatest decisions the United States Supreme Court has ever rendered? And I would suggest to you that we then have to take a look at other decisions the Supreme Court has rendered. Just very briefly, I think it's very important when we talk about why we're standing here today. You can't ignore subsequent decisions like Strickland v. Washington. Think about what that case says and does. It says, today, you're not entitled to a good lawyer. You're not even entitled to a mediocre lawyer. You're entitled to a lawyer who's just above really crappy. It's the truth. And the other piece of that case, you're not even entitled to a fair trial.
Every day in this country, 50 years after this landmark case, people get convicted without ever talking to a lawyer. By now, I should be really used to the reaction, but it always still amazes me that literally people's jaws drop open. I mean, literally, their mouths drop because they don't understand it, and it's news to them, and they are very concerned. And then invariably, when mouths close, the questions start. How is this possible? Why is this happening?
Now, we know that there's not a lot of data, and you'll hear about that, but our best perceptions, I see some people smiling, we need more data collection, and you'll hear that repeatedly throughout the day. However, what we can do is also linked to policy reform. One of the challenges that has been ongoing is that within the indigent defense community, we talk about courtroom representation. We're not focusing on the courts necessarily today. We'll hear about that, right? But it's really about outside the courtroom. How do we become more effective and join arms so that we move forward together rather than just focusing on case by case, et cetera?
There were two architects of the Gideon decision. One of them was Abe Fortas, who wrote the opinion, who wrote the brief and made the oral argument on behalf of Clarence Earl Gideon. And the other architect was Justice Hugo Black, who wrote the opinion of the court. During the course of my remarks, I will describe for you what I believe were the contributions of each of them to the decision. It is the practice of the Supreme Court, when it grants the petition of an indigent petitioner, to appoint a lawyer to represent him, that is, to write the brief and to make the oral argument on his behalf. But the court does not provide any explanation for why it appoints a particular lawyer. So we are forced to speculate on why the court appointed Abe Fortas to represent Clarence Earl Gideon. Fortas was a very close friend of Justice Douglas, dating back to their days at the Yale Law School when Douglas was a professor and Fortas was a student. And Fortas also knew a number of the other members of the court. I think there was another factor that may have been relevant in why the court appointed Fortas to represent Gideon. He was widely known as a public interest or pro bono lawyer. In 1950, Fortas represented Owen Lattimore, the Johns Hopkins professor and the expert on China affairs, in the congressional hearings involving Senator McCarthy's false charge that Lattimore was a Soviet agent. Subsequently, our firm represented many government employees pro bono in the infamous loyalty and security program, and Fortas was deeply involved in that kind of representation. There was one other matter, I think, that important matter that enhanced Fortas's reputation as a pro bono lawyer. In 1953, he was appointed by the U.S. Court of Appeals for the District of Columbia Circuit to represent an indigent petitioner in a case that raised the question of the standard of criminal responsibility. That is, how should we define the insanity defense in criminal cases? The standard at that time, as many of you will know from your law school days, was what's called the McNaughton test, which was a test devised by the English courts in the 1840s, which was whether or not the defendant knew the difference between right and wrong. And in his brief and oral argument, Fortas urged the court to take account of the fact that test was obsolete under modern psychiatric insights, and he urged that a new test be established which is more consonant with contemporary knowledge. And the Court of Appeals in that case, in a famous case called Durham against the United States, decided on a new standard of responsibility, which and ignited a debate about the insanity defense, which has continued to this day.
And so that gives you a rough picture of the mishmash, for lack of a better term, of how public defense is administered across the United States. So how did it become so fragmented? How is it that a case with such a seemingly sweeping decree results in such a patchwork of non-systems? Two answers, one of which is defense of the indigent did not begin with Gideon, and Mr. Kratz stated this, again, thankfully, that there were 45 states that had some level of the right to counsel in 1962. Counties were a different story. There are very few counties that had organized defender systems, 3% in 1961. And I include 1961 to try to show something of the Gideon effect. After Gideon, that number increased to 28% in 1973. And mostly the impact that we've been reviewing as many of the surveys as we can find. And what we found is that a number of the metropolitan areas already had defender offices in place prior to Gideon. And that Gideon's impact was mostly felt in the more rural areas where they were county-based systems.
So at a fundamental level, we tend to think of policy as being made purely by elected officials. Certainly presidents have issue public policies. Many of you, I'm sure, are dealing with, or maybe even been involved in developing executive orders. Presidential signing statements now have become policy in a variety of other areas. And of course, today, you're assembled around one of the most important policy decisions made in the United States, having to do with Gideon, and that's a court decision. That puts you in a very difficult situation in terms of the courts. Judges know very well in terms of how to decide individual cases. Putting the system together is an important context, and so much of what I heard Mark present earlier fits into what I suggest. The most important thing, even more fundamentally, I think, is you need to think about policy as essentially trying to change behaviors. And as I heard the discussion, that seems to be the case here. There are a lot of behaviors that are going on in different states. Public policy is fundamentally about that. You're trying to either get people to stop doing something that they would rather do, or you're trying to get them to do something that they don't want to do. So you're always about that fundamentally, no matter what area you're looking at. That is the essence, really, of public policy. But to even go a little bit more fundamentally, and this may take you back to your methods classes and your statistics classes, policy is a hypothesis. You know, if we do X, Y will result. Okay, but the first thing we've got to have is a sound causal theory. If we do X, Y will result. To the extent to which there is controversy around that if-then statement, to the extent to which there is uncertainty about whether that's a valid theory, then there's more room for opposition. Because you now have legitimacy to challenge the system or to ignore the mandate that's coming down, right? If we don't agree on the purpose, if we don't agree on the means, then there's room then, right, for organizational actors and political actors and interest groups to say, not important, not high on my priority list, right? So you think about, in this sense, everybody's engaged in portfolio management. Everybody's deciding where to put their resources, and you do it every day, I'm sure. Where do I put my time? Where do I put my resources? Right? And a lot of times then, we're going to get resistance if what we're trying to do is viewed not as primary to the mission, but is more viewed as contextual. It would be nice if we could do that, but it's not critical to the central mission that we provide. So we've got to change that decision calculus for those actors who are involved in that decision.
Since 2006, as I told you, the funding at that time was $13.6 million for public defenders. In fiscal year 2012, 2013, it was almost $30 million. We went from 129 full-time public defenders in 2006 to 227 full-time public defenders in 2013. We now have a statewide public defender system that mirrors the structure and organization of the prosecutors. We call them solicitors in South Carolina. We have 16 full-time circuit public defenders. Mr. Malden, seated to my left, is one of them from the Greenville area. I'm also another one. We have the same responsibilities, the same clout, the same salaries, and the same benefit as our counterparts in the prosecutor's office. We have taken positive steps towards trying to create a better system. And Mr. Patton Adams and Senator Malloy will go into more detail as to how we achieved that. But all in all, I can say that I'm very, very proud of what we've done. We have a long way to go. And when I look at what's in the preamble of the South Carolina Indigent Defense Act of 2007, I would just like to read just a couple of the portions of it where it says, the General Assembly finds it necessary to establish a statewide unified indigent defense system to provide effective assistance of counsel to indigent criminal defendants, and the General Assembly believes it is necessary to establish parity in benefits and salaries between prosecution and defense systems in South Carolina. It also wishes to provide for the delivery of public defender services by qualified and competent counsel in a manner that is fair and consistent throughout the state.
So we came up with a very simple, basic, elementary concept of the three-legged stool, that you've got three legs to the stool of criminal justice. You've got the court, you've got the prosecution, and you've got the defense. And unless the stool is level, unless all those legs have a parity with them, then the system is not going to work right, and the dockets are not going to move, and there will be no efficiency in the administration of justice. The key to selling the thing was the efficiency and cost effectiveness of the system. And the three-legged stool concept caught on. It didn't have anything to do with justice now. Harry and I talked about this last night at dinner. That was certainly the end result, and it was the result that we wanted to achieve. But the way we achieved it was not that way, although we knew what our goal was. That's the practicality of this whole thing. because we were trying to create a statewide system and we were trying to get the money for it. I sold it on another way. It turned out, I did a lot of research about these 39 501c3 corporations. Most of them were not in compliance with state or federal law regarding 501c3s. They had not filed their statewide reports, their annual reports. They had not filed the stuff with the IRS. The boards had not met for years. In 2 cases, they had never even gotten 501c3 status. And the state was paying them money. And that's kind of crazy for the taxpayers of South Carolina to be paying their money over to an entity that is going to have to pay it back to the feds. So for those in the end that had any reservations at all in the legislature, I think that pretty much resolved it. What we tried to do, we tried to create a statewide unified system, a system of parity for public defenders. Harry's already told you about that. A system that would provide benefits, retirement, health care, very, very key, very important, not just for retention of public defenders, but for recruiting of public defenders. And we have found that to be more and more true. There are younger folks coming into the system now, and a lot of them are attracted because there are health care benefits and state retirement benefits available.
We had an issue that came up during the Criminal Justice Task Force that we thought was far too complicated and complex to address during the implementation of the Indigent Defense Act. So we moved that forward to put it with the Sentencing Commission, which we did, started a year or 2 later. And so what we did then was reclassify crimes, if I'm answering your question. And so we changed a lot of things in our system. What we saw was we had a system that was broken at that period of time as well. And in that system, we had 25,000 people that were incarcerated in the state of South Carolina. As a result of our Sentencing Reform Act of 2010, we're down to 22,000 in the prison population now, and we see that crime rates have not gone up. And that was assisted with Pew Center on the States, the Pew Charitable Trust, and a lot of other partners that came in. And so we did not decriminalize anything during this process. What we had to do was it was a straight budgetary function as related to indigent defense initially. And so it was a challenge because we passed the act prior to getting the funding. And so during the budget process, we had to make certain that we negotiated for the funding during that time as well.
If we stop with vengeance and we don't think through the fact that our criminal justice system is a human system and it's riddled with error all the time, then we risk putting somebody to death. It's one thing to put somebody in prison for life and make a mistake because they've got the opportunity to come back later, but death is forever. That's permanent. And then, if we execute an innocent person, at that point, we have not 1 murder, but 2 murders on our hands because we're all accomplices at that point if we've executed an innocent person. So I raised this story because the innocence factor, I know, moved several of my colleagues to switch positions. And the combination of that case and other cases like it, with religious people coming in to talk about the fact that perfection and infallibility belong to God and not to human beings, I think moved a lot of people. And there's no reason that new climate of focus on innocence can't be an important factor in terms of the kind of legislative reforms you're talking about, which after all are about making sure that people have lawyers to prevent those kinds of miscarriages of justice from happening.